All right, Chair, looks like we're live.
Good morning. We will call the Cannabis Compliance Board meeting to order. And if we can have a taking of the roll of commissioners.
Great, thank you, Chair. So we'll proceed with roll call. Member Jerry Merritt.
Here.
Member Dennis Nylander.
Here.
Member Rihanna Durrett.
Here.
Member Durrett, you may be on mute.
Here.
Got it. Member Young.
Here.
And Chairman Michael Douglas.
Here.
Okay, great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
We have, sir.
Great, thank you. Chair, with your approval, we will get started by introducing agenda item 1.
Agenda item 1 is public comment. Do we have any public comment this morning?
Chair, we do not have any public comment to start.
All right, that will move us down to item number 2, meeting minutes. We have both consideration for approval of the October 12th, 2020 Cannabis Compliance Board Regulatory Workshop minutes for possible action, as well as B, consideration for approval of October 20th, 2020 Cannabis Compliance Board meeting minutes for possible action. Do we have any clarifications? Because once that's done, we can actually take this in a single item.
Sure. Chair, this is Tyler Klimas for the record. I do have one clarification to make. This is on page 5 and paragraph 5 from the October 20th board minutes. There was an exchange between Deputy Director Miles and Member Durrett. Member Durrett asked Deputy Miles if a company had an owner that was over 5%, but was objecting. Or would they be allowed to remain objecting and not provide his or her identity? So just for the record, Deputy Miles misheard Member Durrett, and he had asked me to clarify in his absence that that any owner that owns over 5% of a cannabis establishment must indeed provide his or her identity and register per the requirements of owners of over 5%, regardless of whether they object or not. So while not an edit to the minutes, just wanted to ensure that that clarification was on the record, Chair. So if there are any questions on that clarification, I'm happy to answer them.
Any questions based on that clarification? If not, if I can have a motion, a single motion to approve the minutes for the October 12th as well as the October 20th respective meetings.
Mr. Chairman, I'm prepared to make that motion. I would move for approval of item number 2, both A and B, approval for the minutes of the October 12th and October 20th, 2020.
For the record, this is Jerry Merritt. I second.
It's been moved and second to accept the minutes for the 12th and the 20th meetings with those corrections. All in favor, if you'll say aye.
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 Aye. Anyone opposed? Anyone wishing to abstain? Motion's carried.
Great. Moving on to agenda item number 3, the consent agenda 3A, the complaints for CCB approval. Chair, members of the board, item 3A concerns 3 complaints for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. I will now present the violations alleged and request the board vote to authorize the service of a complaint for disciplinary action for each licensee. As to licensee A, the complaint will allege violations of the following regulations. 1, violation of NAC Chapter 453D. As to licensee B, the complaint will allege violations of the following regulations. 1, violation of NAC Chapter 453D. And as to licensee C, the complaint will allege violations of the following regulations. 1, violation of NAC Chapter 453D. So with that, Chair, I'll turn this back over to you.
We've received the information that we are pursuant to law allowed to receive as to these possible violations related to complaints for licensee A, B, and C. With that, do we have a motion to go forward with these actions.
Mr. Chairman, I would move, this is Member Nylander, I would move for approval of item number 3A, 1, 2, and 3, as stated on the agenda.
Thank you. Do we have a second?
Rhianna Threat, for the record, I second.
It's been moved in second. Any additional discussion? Hearing none. All in favor of moving forward with these items as the motion states, please say aye.
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 Any opposed? And any abstentions? Hearing none, motion's carried.
Great, thank you, Chair. Moving on to agenda item number 4. This is the request for transfer of interest. Dave Staley, Chief Investigator for the CCB, who's joining us by Zoom, will present this item. Chief Staley.
Chairman,
Good morning.
Chairman, Member Durrett, for the record, either before or after Mr. Staley presents this matter, may I make a disclosure?
It probably would be best if you go ahead and make your disclosure at this point.
Thank you. Member Durrett, for the record, I just wanted to disclose that I interned for Senator Mike Schneider in 2005. Nothing about the internship imparted any confidential information or anything that I think would make a reasonable person partial in this case, or make a reasonable person not objectively impartial. So I'm just going to disclose that, but I'm not going to abstain from the matter.
Thank you.
Good morning, Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I am David Staley, Chief Investigator of the CCB. I'm here to present agenda item number 4, which consists of 2 transfer of interest or TOI applications. Item A are the TOI applications for medical cannabis healing, or MCH. TOI number 18001B requests approval for an existing shareholder, Andrew Schneider, to transfer his 2.24% membership interest to his father, Michael Schneider. TOI number 18001C requests approval for Bauer Horton, Stephen and Valentiana Parlak, Brian Lee, and Paul and Cynthia Rosa to convert various subscription agreements and convertible promissory notes into membership interests in MCH. The subscription agreements and convertible promissory notes were issued by the various individuals to MCH as part of their capital investments during March and April of 2018. The convertible promissory notes will be converted into MCH membership interests if the requested CCB approvals are received. No areas of concern were identified with TOI 18001C. However, staff did identify an area of concern with TOI number 18001B because Andrew Schneider transferred his 2.24% membership in MCH to Michael Schneider, his father, before receiving CCB approval. This is an apparent violation of NAC 453D 315, which was in effect at the time of the transfer. CCB staff have provided potential options for board's consideration to proceed with TOI number 18001B. We've explained those options to MCH executives and have included MCH's responses as Exhibit B to the investigative report. I'm available for any questions, and my understanding is that Tyler Morgan is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I return this item back to you.
Thank you. Before we move further with this, any members of the board have any additional questions or areas they wish to delve into at this point? I would like to hear from our licensee as to this technical alleged violation and what their position is. So if we can get them on our line if possible.
Mr. Morgan, are you able to hear us?
Are you able to hear me now?
Yes.
Good morning. How are you all doing?
Doing fine. Appreciate you being here this morning. The concern was as to what has been alleged as a technical violation of the transfer of interest prior to board approval.
Yes. So on January 4th, 2018, we submitted a transfer of ownership or a transfer of interest request to, I believe it was the Board of Behavioral Human Services at the time that was handling it. We submitted that and we hadn't heard anything. And then subsequently in June, and on that transfer in January, that was essentially Andrew Schneider, who's an owner, was transferring his interest to Michael Schneider, who's also an owner at the time. And he was just transferring his interest because of some legality concerns with a federal license that he was pursuing, and he couldn't have an interest in a cannabis company. So it was two owners related that were essentially just transferring the interest over. Now we submitted that, and then in June, we submitted the subsequent interest, transfer of interest, and that remained pending. And when we submitted that, I had emailed Stephen Rudy at the time. He was the person in charge of the transfer of interests, and his response was just that they'd been backlogged. In the meantime, the state was issuing some agent cards to the prospective owners in the transfer. So when that happened, we were sort of, I guess, mistakenly under the belief that the previous transfer with Schneider must have gone through and that they were in the process of transferring the subsequent one. So I think what happened was the transfer went to the Department of Behavioral Human Services and sort of just kind of froze and got lost in there in the shuffle. It never actually got finalized. And then the second one went to the Department of Taxation. And so we're just trying to get these transferred. However, we're just trying to get them approved, however easiest to do. It was our understanding that the first one was really not much of a request because the two were already approved owners, they're related, and one was just giving his ownership to the other. So there are no objections or anything to it.
Thank you. Other members of the commission have any questions or that they wish to ask at this time?
Yeah, this is Member Nylander. Just a point of clarification for Mr. Morgan, but so we're operating under new regulations now. I just want to make sure you understand that going forward, you cannot do a transfer without prior approval.
Totally understood.
Yeah, and I understand that even it's easy for licensees to see, well, we're both licensed, what's the big deal kind of thing. And I understand that, but the law provides pretty clearly that it cannot be done that way. So I just wanted to make sure on the record that we have an affirmation from you that you understand what the new laws are. Yeah,
and I've communicated with the CCB now moving forward, and it seems like with the portal and everything, things are a little bit clearer and easier to understand. So yeah, that's not a concern moving forward.
Good. Thank you.
Any other members of the board have any questions they wish to ask of the party? If not, positions or recommendations?
Well, Mr. Chairman, this is Member Nylander. My thought on this is that we would go ahead and approve the transfer. This thing's been, sort of festering at various levels, for reasons that had to do with the transition, I think, primarily. So I'm prepared to go forward. I guess the question I have is, it obviously is a violation of the old regulations and there are mandatory penalties. So I guess the approval would, in my view, would need to be conditioned that, the transfer take place when those penalties are paid. I don't know that there's another way around that unless our legal counsel has a different view of it. Or you, Mr. Chairman. who I view as our legal counsel also.
Yeah, the question is, and it indicates in our backup material that the violation that we have, technical violation, potentially carries a maximum fine of $10,000. The question I would have, because we have a technical violation and there's some mitigating circumstances surrounding this, is whether or not we are obligated to impose a 10,000 or set it for hearing as that amount, or whether we can impose less than that amount. I'll call it a token fine for the alleged violation, that either we wind up going to hearing or the licensee would be willing to stipulate to, and we could approve that subject to. So if we have legal counsel about whether or not we can condition this as to a fine less than 10,000, I'd like to hear from counsel as to our ability on that issue.
So Ms. Balducci or Mr. Rath, if either one of you can answer the chair's question.
Chair Douglas, Christopher Rath, Senior Deputy Attorney General. My thought is that if the licensee is agreeable to stipulating to a fine, then I don't think you'd need to go through the hearing process. But if they are not, I think we would need to file a complaint and go through the hearing process. And I believe you have the discretion to go below the maximum.
All right. Thank you. Anyone else have, while we have our counsel on, anyone else have any additional question references? All right. Thank you. I mean, from my standpoint, we have a technical violation. I understand there were other circumstances in play at the time. I would like to see us look at considering approval of the TOI on a stipulated agreement to accept civil penalties in the amount of $4,000. And the license would become final once we could work out an agreement if that's amenable to the licensee. But I would need to hear from the licensee as to that. Otherwise, we are stuck with either looking to approve just flat or looking to refer this to possible disciplinary for review.
So just to be clear, so my options are agree to a $4,000 fine and have both transfers will get processed. And then if I want to argue the fine, then we go to an additional hearing.
Yes, sir.
Can I confer with counsel on our end and have a response to you today? Or does it have to be all right now? It's just that we have so many emails going back and forth.
I understand and I appreciate it and don't want to have you do something you don't want to do. We can move forward with this because the motion will be conditioned upon you accepting that once you got back to us. If you accepted, fine, we would move. It could be wrapped up with the stipulation. If you did not agree with that, then we would have to move on to additional actions. That's where it would be.
Okay. Is there somebody that I can email and contact with our decision maybe by noon today, or this afternoon?
You could communicate with Chief Staley would be fine.
With Staley? Okay. I just would like to run it by our board and just make sure they're aware of it and get approval through them before I make a decision on behalf of everybody. That's all.
No, I understand. And we understand your position as to what occurred. But from our standpoint, we do have a technical violation.
Excuse me, can you hear me? This is the court reporter.
Yes, ma'am.
And the screen went frozen and I could not hear anybody from the point that you were describing, Chairman, it would be wrapped up with a stipulation. If you do not agree with that, then we would have to, and after that, I couldn't hear, or the screen was still too.
If the licensee was not amenable to that, we would have to move forward to considering our other options. One being possibly referring this for disciplinary actions as the alleged violation, or placing it back on the agenda in December for approval and indicating we did not find a violation. Those would be our options. My recommendation to the other members would be to amend the motion to condition approval of the TOI on a stipulated agreement with MCH to accept civil penalties in the amount of $4,000 for the intentional violation of NAC 453D 905 sub 3 sub B 4, and that the license would be conditional until the stipulation is memorialized and signed. And we understand that the licensee is asking for additional time to confer with his board and his attorney, and we appreciate that. So we can take action, and if in fact, after him conferring, if he decides we're going forward, we can have it memorialized and finalized. If he decides that he wishes to pursue other action, then we have to proceed with our alternatives, whichever they be. So, Mr. Nylander, I wish to make a friendly amendment to your motion, if that's acceptable.
Yes, Mr. Chairman. I think that is a reasonable approach for this transfer of interest. The licensee has verified they understand going forward that these types of transfers can't occur without approval. We're under the old regulations, and so I do believe, as you said, it's a technical violation. The licensee has stated on the record that they had a good faith belief that these transfers were already approved based on the other activities that were going on in the legacy agency that heard these. So I think it's a reasonable solution. So I would be willing to amend the motion. The motion would be to approve the transfer of interest, conditioned that there be a stipulated agreement between MCH in order to accept a civil penalty in the amount of $4,000 for the violations of NAC 453D 905 3B4.
We have a motion on the floor. A friendly amendment has been accepted. Do we have a second?
Member Durrett, for the record, I second.
You seconded it? Okay.
Yeah.
With that, any additional questions or concerns that anyone wishes to raise? If not, all in favor of the conditional approval?
Aye.
Please say
Aye.
Aye.
Any opposed? Any abstentions? Hearing none, the motion is passed conditionally, and we will appreciate further contact from the licensee. Thank you very much.
Thank you.
That moves us down to item B on item number 4. That's is it Nutrex? Nutrex. If we
Thank
could
you,
have.
Mr. Chairman. For the record, this is David Staley, Chief Investigator for the CCB. Item B are TOI applications number 19010, 19075, and 21011 for NatureX LLC, in which NatureX has requested approval for various internal transfers to be completed which would ultimately result in 5 existing members selling their membership interests in NatureX to 2 other existing members, Samuel Dorff and George Arkos. After completion of the proposed transactions, Samuel Dorff and George Arkos would each own 50% membership in NatureX through Nevada Natural Treatment Solutions, LLC. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Kimberly Maxton Rushton is present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll return this item to you.
Since you listed no area of concerns, I'll ask whether or not the board members have anything they wish to put on the record or state before we open the floor to the licensee if necessary.
So, Mr. Chairman, this is Member Nylander, real quick for Mr. Staley. This is really just an internal reorganization.
Yes, sir. There were several other, there was a total of 7 owners of NatureX through a couple different intermediary companies. And this will, basically the 5 are selling out their membership interests to the 2 individuals, Samuel Dorff and George Arkos. So it's, the ownership will change to just the 2 of them.
Okay, and they will still hold their interests through Nevada Natural Treatment Solutions, which is the intermediary company?
Yes, sir.
Okay. Thank you.
Any other questions or concerns? Hearing none, then can we have a motion as to this matter, presumably for affirmative in nature?
Mr. Chairman, I would be prepared to make a motion. I would move for approval of agenda item number 4B, Nuturex.
It was a little garbled, but the motion was for approval. In this case, do we have a second as to that motion?
Member Durrett, for the record, I second.
Moved and seconded. Any further discussion? Hearing none. All in favor, please say aye.
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 Any opposed? Any abstentions? Motion carries. Council Rushton, thank you for your being here today to answer any questions if we had. We didn't have any. You've been approved.
Great. Excuse me. Chair, moving on to agenda item number 5. This is the consideration of proposed settlement agreements to resolve disciplinary action. Chris Rath, counsel for the CCB, is available on Zoom here. He will present the 3 proposed settlement agreements for the board to consider individually. So Deputy Rath.
Thank you, Executive Director, Chair Douglas, members of the board. Good morning. L. Christopher Rath, Senior Deputy Attorney General. We have 3 settlement agreements up for approval at this meeting under agenda item 5, A, B, and C. As we did at the last meeting, for each one of the agenda, I will provide you with a brief summary and the Attorney General's recommendation for approval. You may then ask me any questions that you wish, and counsel for the respondents will also be present to respond to any questions you may have. You may then decide on the action to be taken for each. Again, the 3 settlements on this agenda are based on the Nevada Administrative Code, Chapter 453D, which was in effect at the time of the violations. Again, I'd note that the penalties will be larger once we start considering violations which occur under the new Nevada Cannabis Control Regulations, which became effective on August 5, 2020. With that, I will start on the first matter under A, which is Cannabis Compliance Board versus Trike Companies Reno case number 2020-018. This complaint was filed and served on September 22, 2020. Shortly thereafter, and before an answer was due, settlement discussions were undertaken with respondents' counsel. The Attorney General's office, in consultation with CCB staff, came to a mutually agreeable proposal for resolution of this matter, which is embodied in the settlement agreement before you. The allegations in this complaint concern violations of failing to meet seed-to-sale tracking requirements, failing to meet the requirements for disposal of cannabis waste, issues with packaging and labeling requirements, and issues with timely producing records required for the facility's security system. These all involve the respondent's dispensary facility. As set forth in the proposed settlement agreement to resolve this matter, respondent admitted to 2 Category 3 violations and 2 Category 5 violations. Respondent also agreed to imposition of a civil penalty in the amount of $10,000 inclusive of costs. Furthermore, I'd like to note and let all the members know that this licensee did provide a plan of correction that addressed all issues raised in the complaint and is now in compliance. The Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for any questions.
Questions from the board members? If we have no additional questions as to our first proposed settlement, can we have a motion?
Member Durrett, for the record, I move to accept the settlement agreement.
We have a motion for acceptance of the settlement agreement. Do we have a second?
For the record, this is Jerry Merritt. I second.
We have a motion, we have a second. We have any further discussion? Hearing none, all in favor as to accepting the settlement as to the Board versus Trike Companies of Reno, please say aye.
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 Any opposed? Any abstentions? Hearing none. We now move to item number B.
Thank you, Chair Douglas. Item B is Cannabis Compliance Board versus Alicia Castile, case number 2020-016. This complaint was filed and served on August 25, 2020. This is a disciplinary action seeking revocation of agent cards and a $1,250 civil penalty. The complaint contained 2 key allegations. First, it was alleged that on February 21, 2019, the respondent was working at a dispensary when she was only authorized and carded to work at a production or cultivation facility. Second, and more significantly, video footage from that same day revealed that respondent had diverted marijuana by surreptitiously placing cannabis flower into her pocket, which is by itself a revocable offense. The respondent, who was not represented by counsel, decided that she did want to resolve this matter and negotiated with CCB and its counsel to reach an agreement to settle this case. The respondent was advised on multiple occasions that she absolutely had the right to seek counsel to represent her here and or to review the settlement agreement. Accordingly, the Attorney General's office, in consultation with CCB staff, came to a mutually agreeable proposal for resolution of this matter, which is embodied in the settlement agreement we have provided you in your materials. As set forth in the proposed settlement agreement to resolve this matter, respondent admitted to a violation of NAC 453D.365 subsection 3A, which is the diversion of marijuana to a person who is not authorized by law to receive it. This is a revocable offense, and respondent agreed to revocation of her cannabis establishment agent card with the ability to reapply in accordance with NCCR 4.030 subsection 1B after 9 years and 11 months. This particular individual has left the industry. In consideration of this, the CCB agreed it would not seek payment of the civil penalty requested in the complaint. Again, in the settlement agreement, in particular, paragraph 23, respondent did specifically acknowledge she had an opportunity to obtain counsel and seek the advice of counsel. Based on the foregoing, the Attorney General recommends and requests the CCB approve this settlement agreement. I'll take any questions you have.
Questions by board members? We have no questions. Do we have a motion for acceptance of the settlement agreement?
Member Durrett, for the record, I move to accept the settlement agreement.
We have a motion for acceptance. Do we have a second?
For the record, this is Jerry Merritt. I second.
A motion, we have a second. Any additional discussion? Hearing none. All in favor of the acceptance of the settlement agreement as to Mrs. Alisa Castillo, please say aye.
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 Any opposed? Any abstentions? Motion carries. Settlement is approved. That takes us to our third settlement agreement.
Thank you, Chair Douglas. Item 5C is the case of CCB versus Tahoe Reno Botanicals, case number 2020-019. This complaint was filed and served on September 22, 2020. Shortly thereafter and before an answer was due, Respondents Counsel contacted us and we initiated settlement discussions. The Attorney General's office, in consultation with CCB staff, came to a mutually agreeable proposal for resolution of this matter, which is contained in the settlement agreement you've been provided. The allegations in this complaint concern violations of failing to meet the requirements for disposal of cannabis waste and requirements for seed to sale tracking, as well as certain transportation requirements, and in particular, improper transportation manifests. These involve the respondent's cultivation facility. As set forth in the proposed settlement agreement, to resolve this matter, respondent admitted to one Category 4 violation and one Category 5 violation. Respondent also agreed to the imposition of a civil penalty in the amount of $7,888.50, which is inclusive of costs. Furthermore, the licensee has provided a plan of correction for all the issues raised in the complaint and is now in compliance. The Attorney General recommends and requests the CCB approve this agreement. I'm available for any questions that you have, as is counsel for the respondent.
Questions of counsel?
Mr. Chairman, this is Member Nylander. I have a brief question, if I might. Well, I appreciate our counsel mentioning on each of these items that there's been a plan of correction, which is satisfactory. And this is not necessarily just in respect of this item, but with respect to these similar items, which we've now heard a number of them, where, for example, we've got failure to follow the seed to sale requirements, transportation requirements. And I'm wondering if, and this might be more for our executive director, but I would kind of like to see on these an additional exhibit that is just a summary of what the corrective actions were. I'd like to see that as part of our overall consideration, and then have that be in the file so that if we do have, unfortunately, repeat incidents, we can refer back to the corrected plan, and that it be part of the record for the board members anyway.
And Member Nylander, I think we can absolutely do that. The plans of correction are submitted by the licensee and approved by CCB staff. So we can either include that as an exhibit to the settlement agreement and or include it with your materials.
Thank you, and I appreciate that. And just another point of clarification, I don't necessarily want to see the whole plan. And I don't want it to be more work for anyone, but I'd like to see just a summary of it. In
Absolutely.
Thank you.
If there are no additional questions or areas of concern or areas to improve our practice, if we can have a motion.
Mr. Chairman, this is Board Member Nylander. I would move for approval of the stipulated agreement in respect of item 5C, Tahoe Reno Botanicals, as stated on the agenda.
Thank you. Do we have a second to that motion?
This is Jerry Merritt for the record. I second.
We have a motion for approval. We have a second to that motion. Any further discussion? Hearing none. All in favor, please signify by saying aye.
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 Any opposed? Any opposed? Motion carries. That matter is approved, the settlement. That's the Tahoe Reno Botanicals.
Great, Chair. Well, moving on to agenda item number 6. This is the consideration of the dispute over request for change of location between Cheyenne Medical LLC and MediPharm LLC. Again, Chris Rath, counsel for the CCB, will now present agenda item 6 for possible action by the board.
Thank you, Executive Director. Chair Douglas, members of the board, I'm simply going to review some of the background and the key timeline here before you proceed to consider this matter. This matter was continued from the September 22, 2020 meeting and is now before the CCB for possible action after it has conducted further review. Initially, this came before the CCB at the request of CCB staff when Cheyenne Medical, which is also known as Thrive, submitted a change of location request to move its retail cannabis facility or retail cannabis dispensary to 2975 Sammy Davis Jr. Drive in Las Vegas, Nevada, which I will subsequently refer simply to as the subject property. So I'm going to go ahead and provide you a timeline of the key events in this matter. In July 2017, the Department of Taxation approved issuance of a retail dispensary license to MediPharm. On December 6, 2017, Clark County approved the conditional special use permit to put a retail cannabis dispensary on the subject property with an expiration date of December 6, 2019. On December 5, 2018, the Department of Taxation awarded a conditional retail dispensary license to Cheyenne Medical. On June 12, 2019, the Nevada legislature passed Assembly Bill 533, which created the Cannabis Compliance Board and amended NRS 453D.210 subsection 5C to include a requirement that a cannabis establishment license applicant be located at least 1,500 feet away from a non-restricted gaming establishment. On November 6, 2019, Clark County approved an extension of the conditional special use permit for the subject property with a new expiration date of December 6, 2021. On November 21, 2019, MediPharm submitted a request for change of location to the subject property. On November 23, 2019, the 1,500-foot distancing requirement from a non-restricted gaming establishment in NRS 453D.210 became effective. On January 10, 2020, Department of Taxation conditionally approved MediPharm's request for a change of location to the subject property. On May 15, 2020, Cheyenne Medical submitted a change of location to the subject property. On July 30, 2020, Cheyenne Medical signed a profit-sharing lease with the owner of the property. And that's basically the timeline of events as has been briefed by the parties. The CCB may now go ahead and deliberate on Cheyenne's Medical's request to move the property located to the location of the subject location at 2975 Sammy Davis Jr. Drive in Las Vegas. The CCB may vote to grant the request. It may vote to conditionally grant it. It may deny the request. It may vote to conditionally deny it, or it may vote to continue the matter to another agenda. Counsel for Cheyenne Medical and also counsel for MediPharm are available for further questions as well.
Thank you. Members of the board, questions that you might have, or any additional questions you might wish to ask the parties in this matter before we make any statement for the record as to where we're going with this.
Chairman, Member Durrett, for the record, I have a question for Mr. Rath. So part of the legal analysis here, or the legal question we'd be looking at, is whether a change of location is barred by the new NRS that puts that 1,500-foot setback in place, right?
Well, I think what we're, and I don't want to get too much into attorney-client privileged matters, which were outlined for you before, but we were looking at whether really it could be retroactively applied.
To the change of location, not to, specifically to the change of location, not
Correct.
any other area. Okay, thanks.
Mr. Chairman, I do have a question for Mr. Rath. We've heard this matter previously. It's been briefed exhaustively. It's exhausting me for sure. And I do appreciate it. I think we have a thorough record in front of us, both from the prior hearing and the various briefings. But it seems to me that one thing the parties did agree on is that through their briefings, and I'd just like to get your opinion and make sure I'm not reading it incorrectly, is that the grandfather does run with the land and is not specific to any particular license or other entitlement.
That was our conclusion.
Thank you.
Anyone else have questions or concerns, or wish to hear from either one of the licensees as to anything additional? Chair Douglas, for the record, this has been a very perplexing and interesting request for transfer of location that was put before us. We have our predecessor in interest, Department of Taxation, giving a conditional license to one party, subject to them meeting all the conditions. They met part of the conditions, but never, they had, I guess, some kind of conditional landlord approval originally, which came to an end at some point, and they have not been able to reestablish permission from the landlord to go forward. So that's still in the books. The second licensee came forward, made application, indicated they did have approval from the landlord to go forward. They did not have, at this point, they don't have their, it's either a land use survey as the 1,500-foot, at least into us. They might have sent it in since then, but they would still have to meet all the conditions as to landlord and distance information and so on. Only one party can have a license at a location at any given time. So we're in a position where we can grant an additional conditional license. As the underlying issue, we do have seemingly a conflict, even though there are some extenuating circumstances as to the issue revolving around land use. and regulatory laws in certain areas. That would be the distance restriction. But we know that in this matter, and Mr. Nylander was good enough to ask the question, they had approval from the county to place a facility there. That was due to expire. In the interim, they went back, the landowner got an extension to a date which has not lapsed yet to relocate, and that meets with one of the conditions in the state law. So in this particular case, I don't think we are barred by the any distance restriction, even though an argument could be made possibly the other way. But at this point, there seems to be a glitch in the law that I did note, and we need to take up at a future date, and that is the word application, because it indicates that the date of the application for these relocations, but it doesn't signify whether that's the date of the application for license or date of application for the transfer of location. It's not defined. So they both received their licenses prior to any change in law. I think that we are in a position to award a conditional license to Cheyenne Medical. However, a note for the record, it's kind of a race, and that is we have two potential licensees. We would have two conditional licensees with conditional licenses. The first one to meet all the terms could be licensed, and the second one would not be allowed to get a license on that premise, since we can only have one licensee at a location for retail sales. That's my view. If someone has a different view or wishes to add something else, if they would, and then we can get down to whether or not we can fashion a motion in this matter.
Mr. Chairman, this is Member Nylander. I agree with everything you've said. I mean, this is a kind of a thorny situation because the law is not clear. But I also, in looking at these sort of grandfathers, I don't see anything in the record that indicates that the legislature intended for this law, the distancing law, to be required or to be imposed retroactively. And in fact, there's some argument that that's would not be legal in any circumstance. And while I wish that the legislature had made it clear, what they intended to do in terms of these, and I'm not aware of any other application that is in this category where there was an approved SUP by the county prior to and after the distancing requirements. So it's a unique situation, and I'm just drawing back on my experience with gaming, where fortunately the legislature generally through a reviser's note made it clear what the grandfathering provisions were and how the applicants and licensees could go forward. And there were timeframes put in place where certain actions had to be met and certain taxes and fees paid. That was not clear here, but in the absence of that, I just don't believe that the law could be applied retroactively to ban this Thrive licensee and the landlord in particular, who we heard testimony from previously that, he purchased the land with the intent of having a dispensary locate there. And he received all the necessary approvals he needed as a landlord. And if there is no retroactive application of the law, in my view, the transfer could be permitted and not barred by the distance requirement. But the question I have is, what does that leave us with the existing approval that Department of Taxation did with the original applicant? And if we did craft a motion to approve it, this current move, how would we deal with that existing approval? Or is it possible to condition the motion in such a way that there could not ever be more than one license at the location, and both would be found, both would be approved. Only one has the ability to occupy the premises, and let the landlord decide which way he wants to go. Or in the alternative, do we have to rescind the previous approval for Med Farm? So I'm favoring the latter, which is to approve the one in front of us, let the other one sit there. They have whatever actions they need to take in response to that, but clearly they can't occupy the premises without, making a new deal with the landlord. But I think that's more of a business decision from me, not a regulatory matter. So, but as long as we condition it, as you said, Mr. Chairman, that there can only be one license at this location. And if the motion were to be that way, I guess, and if legal counsel wants to weigh, our legal counsel wants to weigh in on, would we have some sort of requirement to rescind the prior approval to move MediFarm? That's a long question. I apologize.
Well, I kind of clumsily touched on some of the things you're talking about. As I indicated, based on our history of the file, we have a conditional license which never finalized. There's no prohibition against us issuing a second conditional license for the location with the necessary requirements for licensure. And note that the law and our regulations indicate only one licensee is allowed on the premises. So even though we can state it, it's part of the law. Then, as you're indicating, it's a business decision for the landlord. Whoever gets the landlord's approval and meets the other requirements as to the certification of the distance and so on, and any other things, would be the one that would be granted the license. I don't think we would have to rescind the conditional. That would, at some points, call for us to put that back on to rescind, which is not really before us today. But I don't think we have to rescind. Either party, if they can meet all the requirements, whoever is first would be entitled to the license. It's kind of a race, and as you said, a business judgment for the actual owner of the property.
Yeah, thank you, Mr. Chairman. That's very helpful for me. I do have a question of our executive director. So procedurally, if we conditioned a motion that there only be one license permitted at this location, procedurally, in terms of staff, I guess there's a whole bunch of things they would have to do in order to perfect the license, all the way down to, there's a final inspection, all of those things before the actual license would issue, or I guess be activated. Would you require any additional conditions other than that the motion include a condition that it's limited to one dispensary license at that location in order to ensure that the process works properly, or is that not necessary?
Thank you, Member Nylander. This is Tyler Klimas for the record. I don't believe, from a staff perspective, we would require any other conditions in there. I think what we have in place, including the documents we'll need and the final inspections, and then, of course, the final check with the local governments would satisfy anything that we needed, and anything that would be required for that licensee to be at that location.
Thank you. Thank you for that response. And I don't have any further questions, Mr. Chairman. And I appreciate that you put your robe on for a while. That was helpful for me.
It was a bathrobe. Other members of the commission, any thoughts or before we look to move forward with this action today?
Member Durrett, for the record, just basically, I agree with how the issue has been framed and Chairman, your comments and Member Nylander's comments. The only thing I would add is I was involved in helping craft and support certain provisions of AB 533, and there were no. This isn't evidence of legislative intent, because legislative intent isn't just the conversations that were being had and what was in certain people's minds. But at that time, I think generally there was no consideration that this would prevent changes of locations going forward. And so I think it's the right, I think moving to allow Cheyenne Medical to go forward with their change of location is correct legally, but it's also policy-wise correct.
Thank you. Anyone else for the record? If not, if we can have a motion, whatever that may be.
Mr. Chairman, I am prepared to make a motion. I would move that the board approve the change of location request between Cheyenne Medical LLC for Cheyenne Medical LLC. And that number on the agenda is RD 263. And that approval be conditioned that there be no more than one dispensary license at the noted location.
Jerry Merritt, for the record, I was second.
It's been moved in second to grant a conditional license subject to compliance with the requirements and that there be one licensee only at the location. All in favor? Well, before I ask that, any additional questions or clarifications? Hearing none. All in favor of the motion for the conditional license, please say aye.
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 Anyone wish to dissent? Any abstentions? Hearing none, the motion for the conditional license is granted.
Great. So we will move on to agenda item number 7. This is the consideration for approval of professional services agreement and equipment lease agreement between Pure Tonic Concentrates LLC, this is RD 456, and Lucid Management LLC for possible action by the board. Chief Staley, he will present this item as he's been working with them on this. So Chief Staley, please.
Chair Douglas, members of the board. For the record, I'm Dave Staley, Chief Investigator for the CCB. I'm here to present item number 7, which consists of a request for approval of a professional services agreement and equipment lease agreement between the Nevada licensee, Pure Tonic Concentrates LLC, and Lucid Management LLC. CCB staff have reviewed the agreements, found them appropriate, and issued a conditional approval letter on October 19th of 2020. That letter conditioned the CCB approval until the date of today's meeting. So then the board will if they agree, will provide the formal approval of the management agreements. I'm available for any questions, and my understanding is that Jake Ward and Thor Hoyt are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
only question I have, there seemed to be in this, the term, it was for 12 months unless there was a change in writing as to this or the sale of this. Would they notify us that they were extending the 12 months because there's not been a sale or something? How are we noting that they're still in compliance at the end of the 12 months?
Sir, I believe you could condition your approval on submission of or notification of an extension to the agreement unless a sale is made.
Are there questions as to this agreement or concerns? And does anyone wish to hear from our parties as to this matter before fashioning some kind of a motion?
Mr. Chairman, I do have a question. I don't know if it's of Mr. Staley or the party's counsel, but I just wanted to get an update on sort of where the receivership is and how long does this thing look like it's going to last?
Mr. Nylander, this, I believe you're referring to the next item on the agenda. Pure Tonic Concentrates is not in receivership, and I'm not aware of any plans to place it there. So I believe you're referring to item number 8 on the agenda.
Yes, my apologies. I thought they were together, but I'll withhold my question until the next item, please.
We wait with anticipation. With that then, if we can have a motion for the approval of the professional service agreement and equipment lease agreement between Pure Tonic Concentrates and Lucid Management.
Mr. Chairman, I'm prepared to make that motion. Would you want to condition it that we have well, I don't know if it's a status check or that they notify us within 12 months of the status of the agreements?
I would refer back to Mr. Clemens. What's better for the department to place the burden on the licensee or to put a status?
I would place the burden on the licensee, and Chief Staley, you could jump in as well, to provide notice if they're going to move for an extension. As I understand it, they have a TOI that's been submitted. So I think the goal of the anticipation is that TOI is up for consideration prior to the 12 months. But I think as long as they give us notice, we'd feel comfortable with that.
Okay. Mr. Chairman, I would move with respect to item number 7 that the board approve the professional services agreement and equipment lease agreement between Pure Tonic Concentrates and Lucid Management, conditioned that the licensees must notify the board 30 days in advance of any amendment to the agreements.
We have a motion for approval subject with the condition of notice as to their underlying agreement status. Do we have a second as to that motion?
Member Durrett, for the record, I second.
We have a second. Any additional questions or concerns? Hearing none, all in favor, please say aye.
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 Aye. Any opposed? Any abstentions? Motion's carried. Now that moves us to item number 8.
Yes, Chair, thank you. This is agenda item number 8. This is the consideration for approval of CW Nevada LLC's profit sharing agreements. Ashley Balducci, CCB counsel, is joining us. She will present this item to the board for possible action.
Good morning, Chair Douglas and members of the board. For the record, this is Ashley Balducci, Senior Deputy Attorney General. I'm presenting item 8 on the agenda. For clarification and context purposes, CW Nevada requested that the Cannabis Compliance Board approve 4 profit sharing agreements for the Alibaba production facility. CW Nevada obtained approval of all 4 agreements from the receivership court prior to submitting these agreements to the CCB for approval. The CCB staff reviewed all 4 agreements and requested more information from CW Nevada. After providing a response to the CCB's request, CCB staff recommended conditional approval on October 8th. CCB staff conditioned the approval as it was not clear as to whether all the parties sharing in the profits had received and or applied for a cannabis establishment registration agent card. This item was discussed at the CCB's October 20th meeting. In the interim, CW Nevada withdrew 2 of the profit sharing agreements for the CCB's approval. There are now 2 agreements before the CCB to deliberate and vote on. We have the receiver, Doton Mellick, and his counsel, John Savage, with Holly Driggs, available for any questions the CCB may have regarding these 2 agreements. Chair Douglas, I'm not sure if you wanted to take them together or separately. I will leave it to your discretion. But the first profit sharing agreement is for manufacturing and production services between CW Nevada and Consensus, and the second profit sharing agreement is also for manufacturing and production services between CW Nevada and Spectrum.
If this is Chair Douglas, if you could give us the background on both of those, and then once we hear that, depending on what is provided, we may be able to take them together, or we may have to take them separately based on the board's concern. So if you would give us the background as to both, we would appreciate it.
I'm happy to give the background, but we also have Chief Investigator Dave Staley, who reviewed the agreements as well, who could provide a background. Chief Staley,
That's
do
fine.
you want me to do the background? Okay.
Whoever is most fluent.
Ms. Balducci, this is Tyler. Why don't you give the quick overview of it, and then with the receiver and the licensees on the line, they can fill in any additional gaps.
Okay, will do. So with the consensus agreement, it's my understanding from reviewing these agreements that they're both for providing manufacturing and production services. Sean Falconbridge, he's the manager of Consensus. He is also available if the board has any questions as well. It's my understanding how the agreement is structured. After reasonable reserves for future expenses, Consensus will retain 70% of net cash from the operations, with the remainder going to CW Nevada. As for the second profit sharing agreement, that too is for providing manufacturing and production services. Aaron Lyons, a manager of Spectrum, is also available to discuss this agreement. From my review of the agreement, Spectrum will pay CW Nevada, and this depends on who's marketing and selling, 8% of the net revenue sharing, if it's CW Nevada selling it, or 3% net revenue sharing if Spectrum sells it. And then 40% of the net cash from operations to Spectrum will go with the remainder to CW Nevada. This agreement's a little bit different than the consensus in that, from my review of it, Spectrum is providing working capital to CW Nevada through receivership certificates that is paid back with 18% interest that must be paid back before any other receivership certificates are paid back. That concludes my general overview of the profit sharing that's occurring between these 2 agreements. Of course, the parties are present to answer any questions that the board may have, or if anything that I have said isn't completely accurate, they may do so at this time.
Before we have other input, Mr. Nolan, it might be appropriate to ask your question now, and that might lead us to other information from either Mr. Staley or the receiver.
Yeah, thank you, Mr. Chairman. I think obviously either one I'm glad to hear from, but I just understand that having read the agreements, there's nothing in these agreements that appears to be unreasonable from a commercial point of view. So whatever their business deals are, it looks fine to me, but I guess the receiver has an obligation, to protect the creditors here, protect the shareholders, and I guess ultimately to put this thing in a position where they can sell it. And I just wanted to maybe hear if I'm understanding it correctly, and then sort of get a status of where they're at on that. And also, Mr. Staley, what are the other two agreements that were approved but are not in front of us today? Are they not going forward?
Board Member Nylander, it's my understanding that the two have been withdrawn for CCB approval and that the receiver will not be requesting CCB approval of those anymore.
Thank you.
Any other questions a board member may have before we ask Mr. Staley or the receiver to comment? All right. Mr. Staley, if you wish to make any remarks in reference to Mr. Nylander's concerns?
Mr. Chairman, Dave Staley, Chief Investigator. I have few comments. I will note that both of the companies that have entered into the services agreement with CW will be contributing some capital to support the operations that they're going to be doing in the CW premises. We did a brief background on each of them with no issues. So we're comfortable going forward with a proposed approval of these two agreements.
If we can have the receiver comment as to Mr. Nylander's query.
Mr. Miller, do we have you on the line?
Sorry, good morning. This is John Savage. Can you hear me okay?
We can.
Thank you. Just for a brief update on the status of the receivership. Yesterday was the deadline for interested parties to submit initial bids for the licenses that are available for sale. Initial bids were received. We did receive at least one bid for each license that met the minimum bids requirements. Those purchasers did also provide proof of funds. There will be some additional evaluation of these bids, but we have a status check set with the receivership court for December 7th, and we're going to provide the court with a full update on these initial bids. And then we also have a virtual auction scheduled for December 15th. That will be run by the receivership's broker, AGP. And the licenses are expected to be sold at the auction on December 15th. And then we will be going back in front of the receivership court for approval of those sales based on the bid that is determined to be the highest and best for CB Nevada and its creditors. And we have final payments due for the licenses by January 15th in time for the deadline under the settlement agreement with the board of January 21st of 2021.
Member Durrett, for the record, may I ask a question, Chairman?
Please.
When the parties enter into the profit sharing agreement and the parties who are allowed to bid, do they already need to be licensed facilities, or the profit sharing agreement and the possible winning bid at an auction are subject to becoming licensed?
The individuals or companies with or without a license are allowed to bid. The two companies involved with the profit sharing agreement were not previously licensed. They Consensus is owned 100% by Sean Falconbridge. He received his temporary agent card on August 3rd of 2020. Spectrum is owned 50-50 between Aaron Lyons and Asia Blackwell. Mr. Lyons received his temporary agent card on October 27th of 2020, and then Asia Blackwell received her temporary agent card on October 15th of 2020. As for interested parties purchasing the license, they are not required to be licensed, and under the terms of the agreement, although licensing and approval by the board would be required to transfer the license, the court order makes the sale final and not conditioned upon board approval. So if the license or if the interested purchaser was denied approval or the sale is denied approval for some reason, there would have to be some efforts to cure that application, or potentially the new purchaser would be required to find a new buyer, I suppose. And the court wanted a final sale to meet the CCB's deadline of January 21st. And so we anticipate some sort of a application review process to follow that.
Thank you.
Any other questions? All right. If we have no additional questions, then we need a motion for either acceptance of both items together or items separately, whichever the maker of the motion wishes to do.
Mr. Chairman, I just have a quick comment. Following up on Member Durrett's question, and by the way, Mr. Savage, that was very helpful, your response, and your laying out the timeline. And within each agreement, there is without getting into any detail, but there is a regulatory compliance requirement which references the CCB's provisions and the Cannabis Act. So, it does outline that there's a need for cooperation and a number of other things. So I'm comfortable with that language, and so I'm prepared to make a motion, Mr. Chairman. I would think that we could take these both together if that's okay with you.
That would be fine.
Mr. Chairman, with respect to item number 8, I would move that the board approve the services agreement entered in between Consensus and the receiver, as well as the services agreement between Spectrum and the receiver as stated on the agenda.
We have a motion for approval of the profit sharing agreements. Do we have a second?
Jerry Merritt for the record. I second.
We have a second from Member Merritt. Any additional discussion? Hearing none, all in favor of the approval of profit sharing, please say aye.
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 Anyone opposed? Any abstentions? Motions as to profit sharing agreements as consensus service agreement and spectrum service agreement are approved. That would then take us to approvals and resolution. Notice of final licensure. No action needed, but status.
Great, Chair. Well, thank you. Yes, agenda item 9, this is the informational item. We present these as notice to the board of the establishments that have been issued their final license since the last board meeting. So we have 2 licenses to note today. The first is Commerce Park Medical LLC. This is RD 239, located at 3698 West Cactus Avenue, 107 to 109 in Las Vegas, Nevada. The final inspection was conducted on October 5th, 2020, and CCB inspection agents noted no deficiencies, deeming it in regulatory compliance. The final license number was issued on October 15th of 2020. The second is Pure Tonic Concentrates LLC, RD 456. This is located at 3555 Construction Way in Winnemucca, Nevada. The final inspection was conducted on July 29th, 2020. Some deficiencies were noted. A statement of deficiencies was issued on July 31st, 2020. CCB agents reviewed this plan of correction submitted by Pure Tonic Concentrates, and on August 18th, 2020, an approved plan of correction was issued. The final license was issued on November 4th, 2020. So with that, Chair, members of the board, I'm happy to answer any questions on these two.
Anyone have questions as to that? Those two items were for discussion only. If not, we can move our agenda to item number 10, briefing to the board by the executive director. There's been a number of things that have occurred recently. We thought it was very important to try to make sure the board was aware of what is happening, reference cannabis regulations, and other things appropriate. Mr. Thomas.
Sure. Thank you, Chair. And so I've got three items today to discuss and brief the board on. The first is agent registration cards. So this is something that has, it's been in the news recently, something the team here has been working very hard on. I'd like to start first and foremost, there has been a delay in issuing both temporary agent registration cards and permanent registration cards. Those are the hard cards. There's a lot of different reasons why we're here, including first and foremost COVID and the challenges it's brought our team members, but also the inability to take credit and debit card payments, the halt to in-person services when the offices shut down due to COVID, and then overall efficiencies and system enhancements that were needed for this agent card system. But I'd like to focus on where we currently are and what other measures we're putting in place to make sure we not only catch up on any of these delays, but to come out of this in a much better place with a much more streamlined process moving forward. Now, as you know, board, there are two types of agent registration cards. There's a temporary agent registration card and a permanent agent registration card. The temporary is issued as a PDF and can be made available as soon as the complete application is received by the board. That means it's been submitted with all necessary information in the application, the payment has been received, and proof of fingerprinting has been delivered. This temporary card process was put into place by law to allow for applicants to begin working in the industry while we wait for the results of the background checks, which can take up to a month to get back. Once we receive an approved background check, we will then print a hard card. This is the permanent registration card, and mail it to the applicant. They have then satisfied all requirements to be a registered agent working in the industry. Given the delay we began to experience, we made the decision to focus the majority of our resources on getting temporary cards processed, because that is really what is required to begin working in the industry. As we sit here today, and due to the efforts of the team here, we have nearly eliminated any delay on the issuance of temporary agent registration cards for complete applications. As long as the application was submitted and complete, payment was received, and proof of fingerprinting was provided, we are currently today on a less than 5-day turnaround time. This, of course, is in addition to the time it takes to mail in the payment. To give you an idea of the progress that's been made, we were at around a 22-day turnaround time on October 28th. Now, normally, a temporary agent registration card is valid for 45 days. However, on November 9th, we extended the date of expiration to January 31st, 2021. A lot of reports lately on delays are in regard to the issuance of the permanent hard card, which exists, not the temporary agent registration card, which is all that is required to begin or continue working in the industry. And as we've made clear through industry notices, we are focused on getting the temporary cards out so there are no delays in employment. Once we are fully caught up on the temporary cards, we will turn our resources to printing and mailing the hard cards. Given the extensions that we've granted, there should be no concerns by anyone in the industry regarding their work status if they currently have a temporary agent registration card. Now, a few things we've done and will be doing to speed up this process. The first was moving the entire application online, which we launched last week. So far, it's been a really great enhancement for us. Applicants can complete the application online now in less than 5 minutes, and it has reduced the number of incomplete applications significantly. Incomplete applications are one of the biggest sources of delays that we see in the agent registration card process. The portal used to facilitate the agent cards does not send automatic emails notifying applicants of missing information. Rather, our team has to do it manually. This requires an applicant who submitted an incomplete application to continue to check his or her email for CCB requests for information. Although the online application has significantly reduced these issues, we're working on coding in more automatic emails into the system to speed the process up. As of yesterday, we have 1,549 applications that are incomplete, so CCB staff are unable to move forward processing and approving them. This could mean anything from someone signed up and decided halfway through not to pursue the application. This could mean they applied but never submitted payment or never submitted their proof of fingerprint submission. Regardless, our team has to go through each one of these applications and let the applicant know what they're missing, sometimes 2, 3, or 4 times. For additional context, this number was at 1,960 on October 28th, so significant progress continues to be made. Additionally, we are currently going through all of these applications and closing out the ones that no effort has been made to continue the application, because as we sit here now, those are still and those remain to be counted in this universe. Overall, board, where we can automate this process at any point, we are moving quickly to do so. Some of the other numbers that I think are helpful and I want to share, this is for the week ending November 15th. We're currently receiving around 76 applications a day, which is over 2,000 a month. We are issuing 92 temporary registration letters on average each day. Even though we've redirected resources, we are still printing an average of 51 hard cards per day. So again, moving in the right direction, we certainly still have a lot of work to do. Now, given our focus on the temporary cards, we do have around 2,800 cards waiting for background check confirmation. Now, some of these we've received the background check results, but have yet to match them. Others, we're still waiting for the background check results to come back to the agency. Once they are matched, a hard card will be printed and mailed. Again, this is a result of directing our agent card team resources on getting temporary cards out as the priority. A couple other measures that we're implementing in conjunction with Director Young at the Department of Taxation. We've worked out a partnership to offer overtime to taxation employees to assist in our agent registration card process. We expect this partnership to get underway in the next week, which should provide some very needed resources to eliminate any delays that still remain. Now, moving forward, I'd say this whole process has allowed us to take a more global look and a global approach to agent registration cards in general. I think there are a number of ways we can continue to streamline this process and continue to cut out any unnecessary information or steps. We're currently working on implementing ACH payments so that applicants and or establishments can use their checking accounts to pay for agent cards. We're also currently working with the Controller's Office to set up a pilot program around revolving accounts, which allow establishments to pay for agent cards from their own CCB accounts, further reducing any delays in mail-in payments. And finally, we're looking at eliminating the need for registered agents to hold multiple cards for multiple establishment types. Rather, make it so one card can detail which establishments the agent is registered to work at. Now, these are just some of the measures that are on our radar in the near term. We continue to examine the registration card process and are open to making any changes that will help the process while still giving us a comfort from a regulatory and enforcement perspective. So a lot of progress has been made by the CCB team, a lot of room for improvement, and this is the right time to get it done. We recognize the importance of making these changes expeditiously. COVID has forced us to get creative, and we're pushing the agency to do just that. I do believe we'll come out of this in a much better place. And finally, I'll say communication remains critical as we work through these system changes. I want to thank leadership and members from both the Nevada Dispensary Association and the Las Vegas Medical Marijuana Association for coming to the table for an open discussion with me and the chair to talk about agent registration cards and the current process. I think it was helpful for both sides and something that is important to continue as we work as partners to ensure this industry remains successful. So with that, Chair, members of the board, I'm happy to answer any questions you may have on agent cards specifically.
Questions or additional comments by board members as to that?
Member Durrett, for the record, thank you so much, Director. That is a very helpful update on these cards. And I'm just really encouraged by your comments that at the things that you're looking at working on to improve the process going forward, because this, you inherited a mess on these agent cards. So thank you so much for thinking outside the box and looking at ways to improve the process.
Thank you, Member Durrett.
If there's nothing, we'll move along to your next.
Okay, great. Chair, you would also ask me to provide an update on disciplinary matters, really kind of where we stand with open investigations from past years. So as we kind of clear the decks here, these are the cases that came over from the Marijuana Enforcement Division when the CCB took hold. As you recall, some of these open cases stretch back to 2018. Our early efforts have been dedicated to addressing these older cases while still continuing to move forward with current regulation and enforcement. So with that, I'll give a brief rundown. For 2018, there were 2 open investigations stemming from 18 when the CCB took over. In both of these cases, a complaint has been issued, approved for service by the CCB. Both establishments are currently in settlement negotiations with the CCB and Attorney General's office. There may be some additional action from one of these matters involving agent cards, but all in, we are in a good place moving forward past 2018. For 2019, there existed a larger list of identified violations and or open investigations. However, they all had varying levels of severity and completeness, truly varied across the board. Thus far, the CCB and Attorney General's office determined 6 to be worthy of further investigation. And upon completion of that investigation, the board has since approved the service of those 6 complaints. The CCB and Attorney General's office, we're going to continue working through that list, but we certainly do not anticipate all of them will result in a formal complaint. We do, however, need to get through these. So it is possible, and I do expect that the board will see some additional complaints from 2019 before we can close out that year. So that's really where we're at for past year issues. We still have work to do to clear out some of the older cases, but we've made significant progress in working to close the book on the transition from the Marijuana Enforcement Division. 2020, we're up to date in 2020. The board has seen the complaints issued thus far this year. We are maintaining, I believe, a healthy balance of working through older cases and investigating new cases as they come up. So before I close, I would just like to thank CCB counsel from the Attorney General's office, Ashley Balducci and Chris Rath. They have worked incredibly hard alongside our agents to move as quickly and efficiently as possible to get through these. So with that, I'm happy to answer any questions from the board members on this update.
Questions or requests for additional information as to this subject?
Great. All right, so finally, my last update is regarding Herbal Choice Inc. and Herbal Choice NLV Inc. This item was discussed at our last board meeting. Both entities are owned by Mr. Norberto Madrigal, who was recently arrested and charged with alleged criminal activity. The board had originally asked Mr. Madrigal to appear at today's board meeting to discuss the renewal request for both his cultivation licenses. Mr. Madrigal, through his attorney, has asked that the matter and appearance be stayed until the criminal case is resolved. The CCB and the Attorney General's office is currently working to memorialize this in a written agreement, which will include the prohibition that Mr. Madrigal will not conduct any operations whatsoever at his 2 currently non-operational cultivation facilities, C111 and C112, until a final determination is made on the renewal. Mr. Madrigal will be expected to come before the board once this criminal case is resolved. So with that, I'm happy to answer any questions either on this or anything else that I've discussed.
All right, I will move the agenda along. Note that our next meeting date is scheduled for December 18th, 2020 at this point. And board members have any items for future agendas or items that they wish to have explored by the Enforcement Division. I for one, the item that was on this morning, I think we need to look at the word application and what that means, because we don't define it. Reference the matter we had on, so that we don't use the application term of when a party was first licensed as the date of application. So when they make requests to do something, TOIs or other things, we go from the date they apply for that item. But we need to look at it and bring it back to the board with what options we have and how that may affect various regulations.
Great.
Anyone else have anything they would like the director to begin to massage at this point? Then that would leave us for public comment. So if we can see if we have any public comment today.
Chair, we do not have any public comment that has come in since the meeting started.
And that leaves us to item 14, the adjournment. I wish everyone a happy Turkey Day as they are celebrating under the circumstances of our tenuous situation. Be safe, be happy, enjoy the family as you can, in the form that you can under the circumstances. And unless someone else has something else for the good of the order, we would stand in adjournment.
Thank you.
Great, thank you.
Thank you. Be safe.
Thank you, Mr. Chairman. Thank you, board members.